Welcome to Moving the Metal, the premier legally focused podcast for the auto finance industry. I'm Brooke Conkle, a partner in Troutman Pepper's Consumer Financial Services Practice Group.
And I'm Chris Capurso, an associate in Troutman Pepper's Consumer Financial Services Practice Group.
Today we're joined by Ethan Ostroff, a partner in our CFS Practice Group, and we will be discussing a recent decision from the Supreme Court of California. But before we jump into that, let me remind you to please visit and subscribe to our blogs. We have two great ones that may be of interest to you, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. Also, we have a bevy of other podcasts that you might find interesting. We have the Consumer Finance Podcast, which, as you might guess, is all things consumer finance related. FCRA Focus, a podcast dedicated to all things credit reporting. Unauthorized Access, a deep dive into the personalities and issues in the privacy, data, and cybersecurity industry. Finally, Payments Pros, a great podcast focused exclusively on the payments industry. All of these insightful shows are available on your favorite podcast platform, so check them out. And speaking of those platforms, if you like what you hear, leave us a review and let us know how we're doing. We'd love to hear from you. Alternatively, please feel free to reach out to us directly. Our contact information can be found on the firm's website, troutman.com. And if you enjoy reading our blogs or listening to our podcasts, please also check out our financial services mobile app. To download it, simply go to your iOS or Android app store and search for Troutman Pepper. Not only does our app have all of our blog content and podcast episodes in one handy place, it also has a listing of all of the firm's financially focused attorneys. So check it out and see what you think. Today, as I previously mentioned, we're discussing the recent decision of Rodriguez versus FCA US from the Supreme Court of California.
So as Brooke said, we've got Ethan with us, who, in addition to being a Tottenham Hotspur fan like myself, and for our listeners, we know this is probably the first time ever that Tottenham fans are going to outflank City fans on anything, let alone a podcast. Ethan is also a partner in our Consumer Financial Services Practice Group. And Ethan, tell us a little bit of background about your practice.
Yeah, thanks, Chris. I appreciate you guys having me on. I do a wide variety of work, both litigation and compliance and regulatory work for companies of all types and sizes, a lot of fintech work and also a lot of work with indirect auto finance companies. So was particularly interested when I saw this decision, Rodriguez, come out and how it might impact manufacturers and dealers and auto finance companies. And I also will just selfishly plug the podcast that I host, The Crypto Exchange, where I'll mention we recently talked about the California DMV putting 42 million car titles on blockchain in an attempt to fight fraud, and look forward to perhaps talking with you all on your podcast about that sometime in the future.
Great. Thanks, Ethan. And as you mentioned, we're going to talk about the Rodriguez decision from the California Supreme Court. And just to kind of orient us a little bit, Ethan, as you know, California, not always a great place to be as a corporate defendant. And so Rodriguez comes in a long line of cases from the California Supreme Court that have an impact on the auto finance industry. So in 2017, the Supreme Court of California issued the McGill versus Citibank decision, which is an arbitration decision and does not have, I would say, a direct impact on auto finance and did not directly deal with legal issues concerning auto finance, but did have important implications for arbitration clauses that might be in retail installment sales contracts. And specifically, the Supreme Court found that an arbitration provision was invalid because it waived a plaintiff's right to seek public injunctive relief. And then just a couple of years ago, we all know the Pulliam versus H&L automotive decision. This California Supreme Court finding that the holder rule does not limit the amount of attorney's fees that a prevailing plaintiff can recover against the holder of a retail installment sales contract if state law authorizes an award of attorney's fees. So a very long-winded way of saying that liability or potential liability in California can be significant in large measure because of the legal framework that has been espoused and created by the California Supreme Court. So Chris, tell us a little bit about the factual background behind this Rodriguez case.
Sure, and this feels like a throwback to law school. The Mr. Capurso described the facts of the case. And it's one of the areas I was good at. So in 2013, the plaintiffs bought, and as soon as I read this, I had to do my best Will Arnett voice, a 2011 Dodge Ram 2500 from a dealer, a used car dealer in California. And at the time of the sale, the vehicle was about 2 years old with a little over 55,000 miles on it. And the 3-year, $36,000 mile bumper-to-bumper warranty on the truck had expired, but the 5-year, 100,000 mile powertrain warranty issued by the vehicle's manufacturer had remained in effect. While the powertrain warranty was still in effect, the plaintiffs repeatedly experienced engine problems and had to take the vehicle into authorized repair facilities for the manufacturer for repair, but those issues continued to persist. Ultimately, they took the vehicle in for repair 5 times. And finally, several years later, the plaintiffs sued the manufacturer for, among other things, violating California's Song-Beverly Act, and specifically that act's refund or replace provision. The plaintiffs had alleged that they had afforded the manufacturer a reasonable number of attempts to repair the vehicle, and that because the manufacturer failed to repair it to conform to the applicable warranty, they were entitled to restitution of the purchase price or replacement vehicle. Now, the manufacturer moved for summary judgment on the ground that the refund or replace remedy applied only to a new motor vehicle, and that plaintiff's car was not a new motor vehicle within the meaning of the act. The trial court held a hearing, and it actually granted the manufacturer's motion. The Court of Appeal affirmed, holding that the phrase in the act, other motor vehicle sold with a manufacturer's new car warranty, does not cover the sale of, quote, previously owned vehicles with some balance remaining on the manufacturer's express warranty. Based on that language, the court construed that disputed phrase as what they called a catch-all for sales of essentially new vehicles where the applicable warranty was issued with the vehicle. And the court distinguished this result from its prior precedent, which had stated that the phrase other motor vehicles sold with a manufacturer's new car warranty covered, quote, cars sold with a balance remaining on the manufacturer's new motor vehicle warranty. The thought being that that phrase could cover a used motor vehicle that still had pieces of a manufacturer's original warranty still in effect. So those are kind of the basic facts without getting too much into the holdings of the prior cases, because that's going to come up a little bit later when we discuss the reasoning of the court.
So I think in the context of the McGill and the Pulliam cases that you mentioned at the outset, Brooke, we sort of saw the tide turning against manufacturers and dealers and auto finance companies. And so this opinion, I mean, it basically overturned about 30 years of case law, right? Because I think since the Jensen decision in 95, I believe, this had been interpreted, the Song-Beverly Act and this provision had been interpreted in the way asserted by the plaintiffs here. And so very interesting that we got a unanimous opinion from the California Supreme Court holding that the state's lemon law does not cover used cars when the vehicle has an unexpired manufacturer's warranty. And so basically found that new automobiles under the Song-Beverly Act applies to vehicles sold as new with full manufacturer's warranties, but not to used ones that come with unexpired warranties. And I think the court went through a pretty straightforward sort of typical analysis that kind of leaves one scratching their head as to how this language, which was, I believe, added in an amendment to the Song-Beverly Act in 1998, took so long to get interpreted. In this case, this Jensen case took so long to get distinguished, I would say, in this context. Because I think, the court did end up discussing the Jensen case and basically said Jensen involved a lease by a manufacturer-affiliated dealer who issued a full new car warranty along with the lease. And the court in this case, in the Rodriguez case, really took pains to limit the holding of that case and basically disapprove of the reasoning to the extent it could be applied outside of that limited factual scenario. So, the court went through a pretty typical statutory analysis, acknowledged at the outset that both the plaintiffs in the manufacturer in this instance had what it described as reasonable readings of how the statute could be construed. I think effectively The plaintiff said, hey, look, this can apply to any vehicle sold with an unexpired manufacturer's new car warranty. And FCA, the manufacturer, said, no, it only applies to a vehicle with the manufacturer's new car warranty that was issued with the sale. And so the court went through the process of its statutory interpretation, looked at the legislative history of not just this act, but other acts by the California legislature, and basically said, look, we think the legislature knows how to make remedies under California statutes applicable to used goods, including used cars. And they didn't do it here in a way they had done it in other places. And that, in their mind, further justified limiting the applicability of the Song-Beverly Act to just vehicles sold as new with full manufacturer's warranties, but not to used ones that come with unexpired warranties.
Yeah, Ethan, I think what I found really interesting about this opinion, one was two things. And both you and Chris have highlighted this word that the court really seems to have grasped onto, and it's the word issue. And that seemed to be the focus for the court. When is the warranty issued? Is it issued at the time of sale, or was it issued at a prior point? And that seemed to be kind of the trigger line for the court here. When is the warranty issued? And that's going to tell you whether or not a vehicle warranty is covered under the Song-Beverly Act. And then secondly, the thing as a opinion nerd and as someone who came through in sort of the new wave of law school, this is a very textualist opinion. So a court that probably is going to have very little in common with Justice Scalia is still following a tradition that he set out on how to read law, how to interpret law, how to structure a legal analysis. And so, Ethan, you're exactly right. It takes a very measured walk through the statute, figuring out what certain phrases mean in connection with other portions of the statute. And then thirdly, Ethan, exactly as you mentioned, we have a court that has given us McGill, a court that has given us Pulliam, and I would not have expected this from the court. It is a decision that, as you said, kind of goes back on 30 years of precedent and winds up with a decision that isn't necessarily unfriendly to consumers, but does not construe the Song-Beverly Act in a way that would be to the manufacturer's detriment. So, Chris, what do you think this means going forward, specifically for vehicle manufacturers?
Before I get to what I think this means for manufacturers, I just wanted to note that you're talking about the kind of textual approach. And what I appreciated as the non-litigator in this triumvirate here is that this is the way I look at things when we're trying to figure out if a statute applies or trying to figure out what kind of requirements may be imposed on any sort of client. Is like, okay, is this term defined somewhere else? Or does the law use this term somewhere else so that we can have an argument later on if a regulator comes knocking that, oh, well, you defined it over here. And it was very refreshing to see the court go through that entire analysis and be like, well, they defined used goods over here. They know how to do that. They didn't do it here. And specifically having the call out to demonstrators in the definition, like they're specifically calling out a sliver of what could be called a used vehicle liberally. So I appreciated that, because sometimes when I read cases, I was like, man, that's not the approach I would take. And I'm not a litigator, so different approaches for different people. But I appreciated that this kind of followed where my logic would go. But to your original question, Brooke, how do manufacturers feel? I'm sure they're elated. I mean, this is wonderful news. And one thing I appreciated is that at the end, even though the court wouldn't talk about it, understandably so, they still outlined the policy arguments of each side and why each side believed that they were correct and the long-standing ramifications of what the court could decide and how it would affect consumers and how it would affect manufacturers. The consumers talked about, you're leaving buyers of used cars just hanging with this worthless warranty, and now we're subject to all these defects. Then the manufacturer saying the chain of title of a used vehicle could go through dozens. I mean, literally, it could go through dozens of people by the time one of these warranties expires. And who knows who's had it. And the intent behind the law was to have the manufacturer be responsible if they were the most recent party. But in this case, it could have gone through many people. It could have been tampered. Any number of things could have happened in there. And the onus shouldn't be on the manufacturer to try to fix something that could have happened 10 owners ago, just because the time period is still there. And I thought it was a fair argument. And, the court obviously didn't get into the policy arguments. And for the manufacturer side, it really didn't matter because they sided with them. But I thought that was interesting. And I think that kind of goes to how manufacturers are going to feel. Now, as Ethan noted, you have 30 years, unbelievably. When he said 30 years and it was 1995, I kind of broke a little. But 30 years of case law about this question about whether a used vehicle could be covered is now gone. And manufacturers can be like, oh, I can actually read the law the way it reads and the way it should read and have it actually apply the way it should apply. So I would imagine they're related.
Yeah. And I think what's interesting for dealers and for auto finance companies is by taking out used cars from the scope of the Song-Beverly Act, you limit slightly the plaintiff's counsel's ability to add additional claims. This is not going to mean that suddenly the plaintiff's lawyers in California don't have the tools in their arsenal to be able to bring suits. It likely just means that there's one fewer claim that's going to be on a motor vehicle-based case. One of the things that I did find interesting towards the end of the opinion was that the Supreme Court addressed some of the concerns about, how do consumers who have used motor vehicles that have some warranty remaining, where do they go? And the court says, okay, you're not without recourse. You go either to the California UCC or you go to the federal Mag-Moss Act. And what's interesting, as someone who often is defending companies that are on the defendants' side, is that plaintiffs' lawyers probably aren't going to like either of those options. One, the California UCC is not going to provide for attorney's fees, so that doesn't necessarily work out well for plaintiffs. And then on the Mag-Moss side, that's a federal claim, and the majority of plaintiffs' lawyers would much rather be in state court. So the prevalence of Song-Beverly claims probably is going to decrease. Whether that's a significant decrease or not still remains to be seen. But for auto finance companies and for dealers, this decision is good news overall.
Yeah, I tend to agree. Good news. Although, like you said, look, typically you're going to see a complaint with 5, 6, 7, 8, 9 different counts, right? And a whole bunch of different defendants all involved. And I think practically speaking, you're just going to see less counts enumerated in the same complaint, but plaintiffs' lawyers at the end of the day seeking precisely the same type of relief and remedies they seek now for the most part. And I don't envision, quite frankly, the valuation by plaintiffs' lawyers of these types of cases changing much.
And with that, that'll wrap it up for today's podcast. So thank you to our audience for tuning in. Don't forget to check out our blogs where you can subscribe to the entire blog or to just the specific content you find most helpful. That's the Consumer Financial Services LawMonitor.com and the Troutman Pepper Financial Services.com blogs. And while you're at it, in addition to blogs, as Ethan noted, check out the Crypto Exchange, which he hosts and releases episodes regularly. And you should also head out over to TroutmanPepper.com and sign up for our Consumer Financial Services mailing list so that you can stay abreast of current issues with our insightful alerts and advisories and receive invitations to our Industry Insider webinars. And of course, please mark your calendars for a great new episode of Moving the Metal, which will be released in 2 weeks. Until next time.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.